As you all know, in the morning we did the right to health. Even though sometimes it's thought of as a narrower topic, I actually don't think it is the way the rapporteur on torture, Juan Mendez, deals with it. This morning we had a physician lead the discussion. This afternoon we have a lawyer, a law professor leading the discussion. So let me turn it over to Juan Mendez, who will then join our panel after his talk. Unlike the rapporteur on the right to health, Juan's been on the job for years and is just wrapping it up. So he is a very senior rapporteur. Can I say that?
Yes.
Okay. All right, take it away.
Thank you. Much, Dr. Anas. Thank you. I want to start by thanking the Boston University School of Public Health for this invitation, and especially for allowing me to share the podium with my colleague, Danius Puras. We don't have enough opportunities to discuss the way we each approach our work, and hearing him today and the comments that he elicited was very helpful to my mandate, even if I have only 5 or 6 months left in it. The crime of torture continues to be relevant, unfortunately, although it's now been a long time since there is an agreement that torture is prohibited absolutely and as a matter of an imperative norm that no state can ignore. And not only torture, also cruel, inhuman, or degrading treatment, which technically is perhaps a lesser form than torture, is also absolutely prohibited in international law. Nevertheless, torture continues to take place in various jurisdictions and under different circumstances around the world today. In addition, the beginning of the 21st century saw some disturbing setbacks in the global fight against torture, with a weakening of the universal moral condemnation of torture in the aftermath of the terrorist attacks of September 11, 2001. However, despite the gravity and negative impact on the global struggle against torture, such setbacks have not only failed to undermine the absolute legal prohibition of torture, but have also demonstrated the relevance and resilience of international legal norms prohibiting torture and setting out attendant state obligations. Indeed, the very attempts of governments that resorted to torture and other ill treatment to deny and cover up their actions reveal that these practices continue to be unequivocally prohibited in both a legal and a moral sense. The legal framework prohibiting torture and cruel, inhuman, or degrading treatment or punishment is one of the most developed in international human rights law. While acts of torture and other ill treatment are proscribed in the main international and regional legal instruments, the prohibition is also a norm of customary international law and enjoys the rare status of a jus cogens or peremptory norm of international law, along with the prohibition of slavery and genocide. Jus cogens norms are basically derived from values so fundamental to the international community that they are considered binding on all nations, irrespective of a state's consent to be bound. The treatment of torture in international law is unique, I would say, together with enforced and involuntary disappearances, among other human rights violations, because each act of torture and of disappearance must be investigated, prosecuted, and punished. It doesn't really depend on whether they are part of a pattern of widespread or systematic torture or disappearances. Each act of these two major violations elicits this obligation. Furthermore, the peremptory nature of the norm authorizes states to institute universal jurisdiction for the prosecution of torturers. This means that prosecution of perpetrators is possible even in a state where the crime was not committed and when neither the victims nor the perpetrators are nationals of the forum state. Whether something legally qualifies as torture or as other ill treatment depends on the specific circumstances of each case. and the determination is fluid. Torture is not an act in itself or a specific type of acts, but rather a legal qualification of an event or behavior based on the comprehensive assessment of this event or behavior. It is also well established that intentional omissions giving rise to severe pain or suffering meet the legal threshold for torture. Intentional deprivation of food, water, and medical treatment, as well as prolonged denial of rest, sleep, sufficient hygiene, or prolonged isolation and sensory deprivation, all of those qualify as torture. In many other cases, however, the determination of whether a certain act or situation crosses the threshold of severity to amount to torture is considerably more difficult. In all cases, the vulnerability of the victim should be taken into account, including factors such as age, gender, or other status like disability, as well as the environment. I also wish to stress, however, that treatment that does not meet the higher threshold of severity necessary to qualify as torture may still inflict pain and suffering associated with the definition of cruel, inhuman, or degrading treatment or punishment. And that is equally prohibited by international law under Article 16 of the Convention Against Torture. Differences in the degree of pain and suffering will always be difficult to ascertain, as they involve both objective and subjective factors. Yet the international prohibition of CIDT is just as absolute and non-derogable, meaning that that no invocation of an emergency can justify the use of either torture or cruel, inhuman, or degrading treatment. Among the most important and disturbing setbacks in the global fight against torture is, of course, the so-called war on terror that the United States and other states launched after September 11 of 2001, and in its limelight, the institutions and practices carried out by way of extraordinary renditions to other states, or carried out at CIA black sites, or rather, and at the Guantanamo Bay detention facilities, all have represented setbacks in the fight against torture worldwide. The situation in Guantanamo Bay involves a number of cross-cutting issues of relevance to international human rights law. These include the practice of torture and other ill treatment, indefinite detention, lack of accountability for state actions, and complicity in the counterterrorism measures that violate human rights standards. Throughout my tenure as a special rapporteur on torture, I have often noted, with great regret, that a number of states have attempted to dilute cardinal principles necessary to prevent and suppress torture and ill treatment, or have become complicit in acts of torture under the rubric of fighting the so-called war on terror in the aftermath of September 11. During the past decade in particular, there has been a rise in the use of torture and ill treatment and an increase in the practice of indefinite detention, amounting to deliberate undermining of the absolute prohibition of torture. In this context, I have argued that the practices of indefinite detention and the use of force feeding at Guantanamo Bay can be identified as forms of ill treatment that in some cases can amount to torture. In the case of indefinite detention, this is arguably a matter outside the mandate of the Special Rapporteur on Torture because it belongs to the mandate of the Working Group on Arbitrary Detention. Nevertheless, indefinite and very prolonged arbitrary detention, I have found and have said publicly that it inflicts pain and suffering of a certain severity, in this case, psychological pain and suffering, that does qualify as cruel, inhuman, and degrading treatment, and in some extreme cases, of course, also to torture. In this, I will discuss the issue of force feeding a bit later and more in detail, but I have also urged the United States government to adopt concrete measures to end the indefinite detention of persons, to provide for their release or prosecution in accordance with due process and the principles and standards of international human rights law, to allow for independent monitoring by international human rights bodies, to close the Guantanamo Bay facility, and to combat impunity and ensure accountability by investigating and prosecuting those responsible for torture, whether committed at this facility or elsewhere. Before the release of the executive summary and conclusions of the Senate Select Committee on Intelligence report last year, I repeatedly urged the United States to back the full release of the report on CIA interrogation practices, reminding the government of the high stakes involved and of the need to respect the rule of law and ensure transparency and accountability. In December last year, I therefore very much welcomed the release of the executive summary and conclusions of the Senate Select Committee on Intelligence report. I truly believe that lasting security can only be achieved on the basis of truth and not secrecy. The committee appears to have conducted a very thorough and frank investigation and analysis of the information available. The report establishes that between 2002 and 2007, the CIA forcibly disappeared, detained, interrogated, and subjected more than 100 persons to torture and other forms of ill treatment as part of the rendition, detention, and interrogation program in collaboration with a global network of more than 50 other states. The use of overseas detention facilities or black sites in locations around the world, including Afghanistan, Eastern Europe, Thailand, and Guantanamo Bay, is well documented. In addition, the CIA rendered other individuals to third countries for detention and interrogation. Despite the fact that these practices were approved and coordinated by high-level government officials and carried out by state agents, criminal and civil or even administrative accountability for the abuses committed is still lacking. The acts of torture and other ill treatment perpetrated as part of the programs were designed to take place extraterritorially and clandestinely, leading directly to the present extant impunity for the violations committed. In this context, the report and its findings have significant potential for compiling evidence that may be used by the state to fulfill its fundamental international legal obligations to investigate, prosecute, and punish those responsible for committing, ordering, or tolerating acts of torture and other ill treatment. In other words, I have said that the publication of the summary of the Select Committee on Intelligence report is a step in the direction of truth, and truth is one of the obligations arising out of the Convention Against Torture. But then, first, truth has to be told more in full, so I've urged for the disclosure of the full report, and hopefully with many less redactions as the summary that has been published. But also that even that would not fulfill all of the obligations of the United States unless and until the United States begins the process of investigating, prosecuting, and eventually sanctioning individuals who participated in any form in the program. The so-called enhanced interrogation techniques such as waterboarding, stress positions, sleep deprivation, forced nudity, insults and violence, and dietary manipulation, among others that have been documented in the report, amount to torture or cruel, inhuman, and degrading treatment or punishment. If not on their own, certainly when used in combination, and especially when coupled with arbitrary arrest, lack of due process, and incommunicado and secret detention. I acknowledge that the release of this report contributes to fulfilling the obligations of the United States with respect to the truth, and it is an important first step in the direction of fulfilling other obligations. But there can be no doubt that the serious abuses detailed in the report constitute basic violations of international human rights law, and that the perpetrators must be prosecuted and punished in accordance with international law. It is important to realize that impunity on the part of the United States sets an example that is a big drawback in the fight against such practice in many other countries throughout the world. I travel to parts of the world in my capacity as United Nations Special Rapporteur on Torture, and I can attest to the fact that many states either implicitly or explicitly tell me, why look at us? If the United States tortures, why can't we do it? The government's reluctance to work with international authorities on the issue of accountability for human rights violations has made it easier for other nations to shirk their responsibility. Let me now turn to another important issue in the fight against torture, and particularly that I have taken action with regards to the United States, and it's the issue of solitary confinement. The practice of solitary confinement is global in nature and is subject to widespread abuse. Although in terms of numbers, the United States seems to lead the world in the number of people who are actually in solitary confinement, unfortunately the example has spread, and it is, solitary confinement is used in many countries around the world. It is often imposed on prisoners for prolonged periods of time and for diverse purposes. Solitary confinement is employed in diverse contexts, including in prisons, administrative facilities, juvenile detention centers, mental health institutions, and immigration facilities. When used in certain circumstances, solitary confinement may lead to the violation of fundamental human rights, including the right to personal, physical, and mental integrity, and may constitute cruel, inhuman, or degrading treatment, and in specific cases, torture as well. In the thematic report on solitary confinement that I presented in October 2011 to the UN General Assembly, I defined solitary confinement in accordance with the Istanbul Statement on the Use and Effects of Solitary Confinement as the physical and social isolation of persons who remain confined to their cells between 22 and 24 hours a day. Although the specific form or context through which solitary confinement is applied, or even the name that it is given, may vary, the fundamental characteristic of the practice is the absence of significant social contact between the detainee and other individuals and with the outside world. Furthermore, given the fact that the physical and psychological harm associated with solitary confinement is often related to the duration of confinement, I define prolonged solitary confinement as any period of isolation which surpasses 15 days. Being one of my principal areas of concern, this definition was based on scientific studies that indicate that after 15 days of isolation, harmful psychological effects often manifest themselves, and in some cases may even become irreversible. So these time limits were recently confirmed, fortunately, in the so-called Mandela Rules, adopted by the United Nations General Assembly in November of 2015. These Mandela Rules are the new names of a document from the 50s called the Standard Minimum Rules for the Treatment of Prisoners. And the review included several important innovations, including with respect to solitary confinement, but also for, on the standard of health care of detainees held anywhere in custody in the world. This document has always been a very highly regarded instrument, and now with the new revisions, they include a prohibition on indefinite solitary confinement and a prohibition on prolonged solitary confinement, defined as any term exceeding 15 days. So obviously, it also includes prohibitions on using solitary confinement for any length of time, even for hours, against children, against any person with any mental disability, and against breastfeeding or pregnant women. Solitary confinement can produce adverse health effects in an individual after only a few days, with the risk of serious and irreparable harm increasing with each day spent in confinement. Research on the effects of solitary confinement has revealed certain psychotic disorders, including a syndrome known as prison psychosis, whose symptoms include anxiety, depression, irritability, cognitive disorders, hallucinations, paranoia, and self-inflicted injuries. In particular, prolonged solitary confinement may lead to the irreversibility of those effects. The practice of prolonged solitary confinement may constitute cruel, inhuman, and degrading treatment or punishment or even torture, given that the longer the duration, the greater the risk of serious and irreparable harm to the inmate. In my report of 2011, I did say that the use of short-term solitary confinement can be justified in some circumstances, provided that adequate safeguards are in place. Prolonged or indefinite use of solitary confinement can never constitute a legitimate tool for states to use regardless of circumstances. This is not to say, however, that solitary confinement lasting 15 days or less never constitutes ill treatment or torture. The assessment of whether it does should take into consideration all relevant circumstances on a case-by-case basis. These circumstances include the purpose of the application of solitary confinement, that is, for disciplinary reasons or for any other reason, the conditions, length, and effects of the treatment, and of course, the subjective conditions of each victim that make him or her more or less vulnerable to those effects. With regards to the purpose of application, solitary confinement is often used within prisons as a form of punishment for serious disciplinary violations, and sometimes for less serious disciplinary breaches as well. States often use solitary confinement as an administrative or protective measure, even without the person actually asking for any kind of protection, so as to segregate certain vulnerable prisoners from the rest of the prison population. Such vulnerable groups often include new inmates, juveniles, and LGBTI prisoners. However, under no circumstances should solitary confinement be applied to, as I said, to children, to persons with mental disabilities, or to pregnant or breastfeeding women. In addition to these adverse health effects, solitary confinement may also give rise to other acts of torture and ill treatment because of the prisoner's lack of communication with the outside world, as well as the lack of witnesses inside the prison. It must thus be used under exceptional circumstances and only as a measure of last resort. Where it is admissible and justified, as I said before, the duration must be as brief as possible and must be announced and communicated to the individual with a minimum due process guarantees. Persons being held in solitary confinement must be afforded effective remedies and opportunities to challenge the reasons and the duration of their confinement, and must be allowed access to legal advice and medical care, including eventual judicial review of the measure. Considering the framework of this conference and this prestigious school, I would like to talk to you about the indivisibility and interdependence of the right to health and the principle of freedom from torture and ill treatment, and how this applies to a detention setting. On the one hand, we have the prohibition of torture. As I have discussed in my introductory remarks, this prohibition is absolute and non-derogable. On the other hand, the international community has also recognized the right of everyone to enjoy the highest attainable standard of physical and mental health through the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and other international treaties. When it now comes to prisons or other detention settings, the provision of health care in order for prisoners to enjoy that highest standard of health is a state responsibility. Health care arrangements must be adequate for each and every prisoner. A sharp deterioration in a prisoner's health inevitably gives rise to questions concerning the adequacy of health care, and state authorities will be under an obligation to account for this treatment of detainees. Failure to safeguard the physical integrity of a detainee by providing appropriate medical care may even give rise to a violation of the absolute prohibition of torture and ill treatment. The most important principle when it comes to the right to health in prisons is that it is no different to the right of health for non-detained individuals. The principle of non-discrimination applies here. As Article 12 of the Covenant on Economic, Social, and Cultural Rights establishes, states have an obligation to respect the right to health by, inter alia, refraining from denying or limiting equal access for all persons, including prisoners or detainees, to preventive, curative, and palliative health services. In General Comment 14, paragraph 34, the Committee on Economic, Social, and Cultural Rights expanded on this. Everyone, including prisoners, have the right to enjoy the highest standard of physical and mental health. The standard minimum rules establish that inmates have a right to the same standard of care as is available in the community. If the prison's health services cannot provide the care an inmate needs, he or she must be transferred to a hospital. In reality, unfortunately, I have seen in many detention centers I visited that the access to health care is either totally lacking or very, very inadequate. The reasons can be manifold, and lack of resources is often quoted. Chronic illnesses go untreated, emergencies are ignored, and patients with serious mental illness fail to receive necessary care. For some patients, poor medical care may even turn a minor sentence into a death sentence. However, as pointed out above, the health care of prisoners is a state responsibility, and delivering on it is not optional. We also have to understand the reality that prisons inevitably contain higher percentages of individuals with health problems than is the case in the population in general. This is particularly true for mental health problems, but also for communicable diseases such as tuberculosis. Many inmates, furthermore, suffer from problems associated with drug abuse. In addition, the very fact of imprisonment is likely to lead to a deterioration in a prisoner's physical and mental health unless positive steps are taken to provide an adequate regime of activities. There is thus a need to ensure that a prisoner's health is monitored not only at the time of admission, but periodically thereafter. A failure to do so and a subsequent denial of access to health care or inadequate health care can amount to ill treatment and even torture of the detainee. The Mandela rules that I have already mentioned therefore contain detailed guidance on health care in prison and on the role of health care staff. Among other topics, they outline that the health care service in a detention center shall consist of an interdisciplinary team with sufficient qualified personnel acting in full clinical independence and encompass sufficient expertise in psychology and psychiatry. A qualified dentist must be available to every prisoner. Urgent cases must be given prompt access to medical attention. And prisoners who require specialized treatment or surgery shall be transferred to specialized institutions or to civil hospitals. The principle that healthcare arrangements must meet the needs of individual prisoners is of particular relevance in relation to individuals who are particularly vulnerable. Thus, in the case of mentally ill persons, an assessment of detention conditions must take into consideration their vulnerability and their disability, and in particular the medical condition of the prisoner, the adequacy of the medical assistance and care provided in detention, and the advisability of maintaining the detention measure in view of the state of health of the prisoner. Also, in relation to persons with physical disabilities, particular attention is required. For example, the need to ensure that detainees are provided with any specialized aids to help them cope with imprisonment. A failure to provide these vulnerable groups with adequate access to health care, taking their condition into account, can amount to ill treatment and even to torture of the detainee. On the other side of the same coin, there is also the inappropriate treatment of a detainee, and not only the failure to provide appropriate medical care that may result in a violation of the right to be free from torture and inhumane treatment. This is particularly important when it comes to forced treatment, including forced feeding of detainees on hunger strike. As you're aware, in particular, numerous Guantanamo Bay detainees, as well as other inmates in the U.S. Prisons in the mainland and in foreign detention facilities, have opted for these extreme measures in the last few years. In this respect, it is important to recall that acts or threats of force feeding of individuals who have opted for the extreme recourse of a hunger strike in detention, as well as other types of physical or psychological coercion against them, may constitute cruel, inhuman, or degrading treatment, which in turn may amount to torture. I have therefore denounced such practices publicly numerous times in respect to the hunger strike in Guantanamo, but also 2 years ago during the hunger strike in California prisons protesting solitary confinement. I consulted the medical professionals on the ethics of force feeding before I made a public pronouncement, and I am confident that the autonomy of the prisoner continues to be paramount, at least until that autonomy, that capacity to decide for him or herself is no longer available. The state should refrain from force feeding. And then we learned about how force feeding actually proceeds through, you may have seen that Al Jazeera obtained documents explaining how force feeding was to proceed in Guantanamo, that were actually borrowed from the way force feeding proceeds in several state prisons or federal prisons in the mainland. I don't have any doubt that the treatment is so severe, so painful, that it rises to the level of pain and suffering associated to the definition of torture. My mandate has received information about painful and humiliating procedures of force feeding applied at Guantanamo Bay, which involve detainees being strapped to a chair while a feeding tube is roughly inserted through the nose into the stomach and roughly extracted. In addition, detainees have reportedly remained strapped to the chair for several hours afterwards in an attempt to prevent them from regurgitating the food. In this context, I have in the past expressed my support for the findings of the Inter-American Commission on Human Rights of the Organization of American States and the UN Special Rapporteur on the Right to Health that have stated that in cases involving people on hunger strikes, the duty of medical personnel to act ethically and the principle of respect for individual autonomy must be observed. Under these principles, it is unjustifiable to engage in force feeding of individuals contrary to their informed and voluntary refusal of such a measure. Moreover, hunger strikers should be protected from all forms of coercion, even more so when this is done through force and in some cases through physical violence. Healthcare personnel may not apply undue pressure of any sort on individuals who have opted for the extreme recourse of a hunger strike, nor is it acceptable to use threats of force feeding or other types of physical or psychological coercion against individuals who have voluntarily decided to go on a hunger strike. Inevitably, when I've gone public on these things, the first question that I'm asked by journalists is, so you're going to let them die? And I have said, no, I still make the state responsible for the health and survival of the person. But I urge the state to use every other means at its disposal, including negotiating with the hunger strikers, rather than recourse as a first resort to force feeding. It is my firm belief that the desire of the inmates not to eat must be respected for as long as it is clear that they are making that choice voluntarily. Even if it is intended for the benefit of the detainee, feeding induced by threats, coercion, force, or use of physical restraints are tantamount to cruel, inhuman, and degrading treatment. Prisoners' rights to control their health, body, and to be free from interference, such as non-consensual medical treatment, are also fundamental elements of the right to health that must be respected and protected. I do not believe that the prison authorities should let inmates starve to death, but I insist rather that the authorities have a duty to look for other solutions to the crisis created by the hunger strike, including good faith dialogue with the inmates about their grievances. Lastly, I would like to touch briefly upon the importance of medical and forensic documentation for the purposes of investigation and prosecution of torture allegations. My esteemed colleagues here on the panel today may be able to elaborate more on this. I just quickly point out the key role that forensic science, and in particular medical forensics, play in this field. As I have mentioned earlier, states must exercise due diligence to investigate, prosecute, and punish violations by both state officials and private actors under certain circumstances. They must do so whenever there are indications of torture or other ill treatment, even without an express or formal complaint. Such an approach should be followed whether or not the victim bears visible external injuries. In this field, effective medical and forensic documentation is paramount and can bring evidence of torture and other ill treatment to light so that perpetrators may be held accountable. This scientific evidence is also crucial to the effective implementation in practice of the exclusionary rule in the Convention Against Torture that obliges states to exclude statements obtained under torture from any proceeding against a person making the declaration. During my fact-finding visits, I often observe that there are no routine medical examinations and that recourse to forensic expertise is at the discretion of the authorities, police, prison guards, prosecutors, or even judges, and is usually denied. Private forensic examinations are simply unavailable to most for lack of resources or because competent private expertise is non-existent in the community. In many torture cases, there is either a lack of any medical documentation because survivors are not examined by a doctor, or there is poor quality in forensic medical reports because examinations are done by unqualified doctors who are not compliant with the standards outlined in the Istanbul Protocol. This fuels impunity as it enables authorities to dismiss the allegations at the initial investigatory stage. Poor quality reports are even used by authorities to rebut the testimony of survivors rather than to corroborate it. Independent and professional forensic specialists can address this by providing expert analyses of whether there is a correlation between the medical evidence and the allegations. They can provide the evidentiary basis on which prosecutions can successfully be brought against those directly responsible and their superiors, and they can provide the scientific basis to exclude evidence that may have been obtained under any form of coercion. Medical records can be instrumental in overcoming the otherwise lack of objective evidence with which survivors of torture are so commonly confronted, given that torture mostly takes place without witnesses. The work of a forensic scientist is thus germane to the efforts to address impunity for acts of torture, as the expert opinion forms the evidentiary basis for prosecution of allegations of torture. Similarly, the corroborative effect of this professional opinion and its role in assessing the overall credibility of alleged victims provides a stronger basis for prosecutions. This not only increases the chance of a successful prosecution, but also enhances the possibility to receive immediate medical and other assistance, and in the longer term, other forms of redress and reparation. I am sorry to have gone on too long, and I really welcome your comments in the next segment. Thank you very much.
I'd like to get a couple questions first. I'll get the panel to come up here while Lon will take a couple questions first while we're waiting there. Yes, go ahead. We can wait for the microphone.
Hi. Hello. Hi. I'm curious as to your opinion on the role extradition laws play in the international community, and furthermore, can it be considered a human rights violation or a violation of the right to be free of torture to allow for the extradition of a criminal to a country known to practice acts of torture, or this might be a separate question, but a country known to support capital punishment?
I'm sorry, I think I missed the first part. You're talking about force feeding or?
Rendition, I think.
Oh, rendition.
Yes?
Yeah.
Extraordinary rendition? Well, extraordinary rendition violates many different aspects of international human rights law. First and foremost, the right to be free from arbitrary detention. But what we mean by extraordinary rendition is that somebody is detained without an explanation of the reasons and without a judicial authority determining that there's minimum grounds for putting that person into custody. Then it violates another very important principle of international human rights law, and that is that the minute you are arrested, you have a right to have an independent authority, a judicial authority, determine the legality of the arrest and the conditions under which you're being arrested. In extraordinary renditions, nobody knows where the person is, and of course, they are completely outside the reach of an impartial and independent judiciary. And thirdly, it violates the right to physical and mental integrity. Even if we don't know what's happening while the person is in extraordinary rendition, but it does give the opportunity for very, very serious physical torture to happen. And from what we know, the real reason for resorting to extraordinary rendition is precisely to be able to torture people. But even if torture doesn't happen, the uncertainty, the lack of communication with the outside world, the prolonged or indefinite nature of the detention inflicts by itself mental pain and suffering that easily meets the definition of torture in international law. I'm sure I'm missing a couple of other violations that are involved in this, but let me just say that extraordinary renditions are a form of disappearance. Maybe temporary, maybe not definitive, maybe the people are not eventually killed and their bodies hidden, but international law has defined disappearances as meeting all of these criteria that I just mentioned, and so extraordinary rendition is just a euphemism for disappearance.
Thank you very much for your comments and for speaking to us today. My name is Sarah. I'm a student here at the School of Public Health as well as the School of Social Work. As part of my clinical training, I've been working with torture survivors here in Boston who are also asylum seekers. And I'm wondering if you can speak to the responsibility of signatories under the UN Convention Against Torture to protect asylees who are torture survivors from being returned to their country of persecution and torture.
Right. Well, my rapporteurship gets involved a lot, and so does the Committee Against Torture on treatment of asylum seekers particularly, because the Convention Against Torture includes a specific prohibition on sending anybody to a country where he or she is at risk of being tortured. And that's, we call it the non-refoulement provision, but it is similar but somewhat different from the non-refoulement provision in refugee law, because the non-refoulement provision in refugee law, on the one hand, protects from more than torture. A refugee or an asylee cannot be sent to a place where he or she would be persecuted in many different forms. But the Torture Convention only protects against the risk of torture. But on the other hand, it's more protective because the non-refoulement in refugee law requires for the person already to be designated a refugee or an asylee. And so unfortunately, if they're denied asylum, they can be sent back, even to where they might be persecuted. Whereas the non-refoulement provision in the Convention Against Torture applies to anybody, even to the worst criminal. Someone who is not entitled to refugee status still cannot be sent to a place where he or she would be at risk of torture. So the other things ways in which we get involved is not only in protecting people from being refouled, but also on the debate about what survivors of torture are entitled to. The convention does say that they're entitled to reparation and to rehabilitation. And there's a debate with countries as to, yeah, but who is obliged to do that? And some states, especially states that receive many asylum seekers, like the United Kingdom, they claim, well, that's an obligation that's not on us, it's on the state that did torture them. We and the civil society of the United Kingdom at least engage a dialogue. I mean, I cannot say as a matter of international law, no, the United Kingdom has to provide rehabilitation services, but we do urge receiving states also to, just out of a sense of humanity at least, to contribute to the rehabilitation and reparation of the harm suffered by torture victims, even if their state agents weren't originally responsible for the torture.
Thank you. I'm going to ask you to join the panel now.
Yeah.
We got a lot to talk about. I mean, needless to say, our panel is Dr. Sandra Crosby, Dr. David Annis, and Dr. Reynolds. All right, we are. Where to start? We're going to get into force feeding, but why don't we start with some real cases? Well, first, do you guys have any comments on the presentation?
I have a question for Professor Mendez. So in talking about the obligation under the Convention Against Torture for rehabilitation to be interrogated and tortured by the United States in the war against terror and then released to third countries, other countries, without any treatment or reparations. And we've actually searched the literature and determined that we've probably arrested, interrogated, and released between 80,000 and 100,000 people in the war against terror. What do you have any opinion on how to tackle that, or what is the United States' obligation?
Right. Well, I can't associate myself with the figures that you gave because I haven't seen that evidence, but of course I look forward to seeing it. Nevertheless, I think under the Convention Against Torture, there's the state whose state actors have committed the torture is first and foremost and undoubtedly obligated to provide for rehabilitation services, including reparations. So it's not a question of whether they have to do it because of humanitarian reasons. They have to do it for legal and moral reasons. And also, it doesn't depend on whether the former detainee is still within the reach of the rehabilitation services that the United States, in this case, can offer. If these persons are in another jurisdiction, but they need rehabilitation services, the United States has to provide at least the means for the rehabilitation services to be rendered. Now, the problem is determining what rehabilitation services are needed, and that will depend, of course, on the diagnosis of what what the long-term effects of their torture continue to be. Of course, rehabilitation, means different things in different contexts and for different people and for different situations. But the the Committee Against Torture issued not long ago, I think in 2014, one of its third general commentary on the convention, precisely about reparations and rehabilitation services. And it provides some guidance, at least, as to what would be required.
Did you just make up that 100,000 figure, or do you have a source for it?
No, we actually, in our department, went through years of public records and press and determined that from the beginning of the war against terror, people who were arrested and released from sites such as Abu Ghraib, Bagram, Afghanistan, other sites, probably amounted to between 80 and 100,000 people.
And there were, I don't know, easily 800 or 1,000 immigration detainees in the early months after, within the United States, I mean, in the months right after 9/11. Figure was never really public. The Justice Department under the George W. Bush administration said that they were conducting arrests, but they were not informing the public about who was arrested, names, figures, anything.
No, that's right. There's no government record of that. That's right. David, do you have a comment or question?
Just excellent talk. Thank you very much. I do have a couple of questions, and we may be getting into the force feeding a little bit later, but just a couple of comments to start out with. And the question of solitary confinement in general is a really important, topic in general. There's the way I think we sometimes look at the folks in prison is that they're being punished by being restricted, so that's their punishment. And then once they're inside, there's some folks, maybe it's culture, I'm not sure what it is, but to some extent where certain people, be it the COs or maybe even the medical staff or someone, has this belief, conscious or otherwise, that they need more punishment or something like that. And I think that there's a little of that sometimes drives some of the decisions that are made. That being said, they also want to come up with some kind of program, some sort of process by which, if you do commit a crime once you're inside a prison or a jail, that there's some punishment. And obviously, you can't just lock them up because they're already locked up. So what's the next step? What can you do? And then the question of what is a humane way to develop some sort of punishment system when it comes to that. And then there's the question you brought up about mental illness and those who have serious mental illness and whether they should ever be in solitary or not. There are programs, at least in New York State, where Dr. Reynolds and I work, where there are special programs for those who have mental illness and also have done something to get to the point where they've been given solitary time. And I'll leave it to Dr. Reynolds to give the details of that, but it shows at least that if the solitary SHU, or whatever you want to call it, system works to some extent with the general population, which may not be the case, but if it does, there is a way there at least are some programs where you could do it similarly with those with mental illness. But I'll leave that up to Dr.
Did they
Reynolds.
follow the 15-day limitation on these?
There's a couple of things. One of them is that if you agree to participate in a program, a lot of these folks might have mental illness or symptoms, but not want any treatment or not want to try to participate in some kind of treatment. But it's sort of, in a sense, a course of treatment to some extent. But it's an incentive to reduce the time that you have if you participate in some of these programs. And it's not always medications, too. It could be like groups and things like that. But I know that that's one of the ways of mitigating the sentence itself. As far as the 15-day rule, I'm going to pass it over.
Brandon, yeah, you can continue.
Sure. First, I'd like to throw out some caveats. So, if I may. Firstly, I have been employed with the New York State Office of Mental Health, working full-time in the correctional system at the state level for the past 3.5, 4 years or so. I view our system in New York as working reasonably well. But again, that brings up the argument, at least when you're talking about American incarceration, whether it's the problems of mass incarceration or over-penalizing drug use and possession or the racial disparities. When it comes to America, you're really talking about at least 51 different systems. So I can speak to my experience in the state of New York, which may be different from those learned members of the audience who are familiar with how things work in Massachusetts or Rhode Island or Connecticut. To your point, Dr. Annis, about how the system works now, I would point the audience and the panel, I would refer them to the recent settlements between Governor Cuomo and the New York branch of the ACLU, or American Civil Liberties Union, the NYCLU, which further modified down the typical kinds of sentences and offenses eligible for solitary confinement. I think very much in the spirit, at least, of your presentation. So first-time or low-level drug offenses, and this was reported in the New York Times a few months ago, but first-time or low-level drug possession or simple drug use typically won't be eligible for penalties of solitary confinement as they had been up till now. The typical duration of solitary confinement going forward under this agreement, which I believe will be fully enacted in another couple of years or so. So there's some lag time to give the system time to implement and make all the policy changes. But the typical duration will be somewhere around a month or so, with allowances for longer periods in the more extreme cases of violence or assault on staff, assault on other inmates. So I just want to make that point as well, that again, at least speaking in terms of New York State, a lot of the system that Dr. Annis and I have worked in has been the result of ongoing advocacy as well as debate, negotiation between the state-level government and, under us, Governor Cuomo, and the other officials in Albany and the rest of the state government, either making deals with these private advocacy groups or, in some cases, enacting laws that affect our day-to-day operations within the system. So, for example, in the state of New York correctional system, the typical mental health patient could expect to be seen by an outpatient psychiatrist up to every 12 weeks or every 3 months or so. But if they are in solitary confinement, they get seen by someone like myself every 30 days, on top of twice, I want to say bi-weekly sessions with a social worker or psychologist, and that's just for people who are currently active within the mental health system. They also receive more frequent screenings, even if they're not currently active in mental health, just to see if they're having any issues or want to be, have any issues that they want to be addressed in a formal mental health setting. But even that has to be counterbalanced against their other rights, where they have inmates and those who are incarcerated still have a right not to talk to mental health as well. So we have to balance those things out. What Dr. Annis, I'll just make this one or two final points before I.
How about one, Brandon?
Well,
We'll be back to you. We'll be back to you.
I will just leave off with this for now, that in addition to talking about the differences between the states, a lot of that also has to do with the jargon, semantics, and nomenclature of what we're talking about. So I think that's one of the most important things to remember when we're talking about solitary confinement, is that not only is it enacted and operated differently state to state, but some of the terms that it might go under and what people call it, and other kinds of similar but different kinds of confinement, that we have to keep track of solitary confinement versus administrative segregation versus protective custody versus keep lock, and those kinds of things, system to system and within the systems.
We should get back to you later.
Fair enough.
Give a little more definition.
Yes, Juan.
Still on solitary confinement. Let me say first that there's very good news about solitary confinement in the last 3 or 4 years in the United States, and I think also moving towards the rest of the world as well. And that is that there's been litigation and negotiations that Dr. Reynolds has mentioned. This has been aided enormously by President Obama himself, taking on the question of incarceration generally, but specifically solitary confinement as well. So I think we are at least seeing a kind of a recognition of the problem that was, ignored until now, with 80,000, maybe 100,000 people in solitary confinement at any given day in the United States, and people didn't really know what that, one, that it had actually happened, and two, what it is. Now, of course, Dr. Reynolds is quite right that the different prison systems call it different things. For example, when I first heard of this, it was in the case of Bradley Manning, now Chelsea Manning. She was being held in conditions amounting to solitary confinement at the brig in Quantico near Washington, but the commander of the brig said, no, this is not solitary confinement, it's, I think he called it prevention of harm watch. Anyway, we negotiate. I actually filed a case with the United States government, and I entered into negotiations about the case with the Department of Defense. And when she was moved now to Fort Leavenworth, she was no longer put on solitary confinement. But that, piqued my curiosity. And then I learned, for example, that people who are accused of terrorism offenses, some still under prosecution, but others after conviction, they are put in what is called special administrative measures, SAMs, in federal prisons. The most important thing is that when you ask for what are the conditions, they amount to solitary confinement as defined in the Istanbul Protocol. That said, not the Istanbul Protocol, another Istanbul document called the Istanbul Statement on Solitary Confinement, that says that any period in a given 24-hour period of 22 to 24 hours spent alone is solitary confinement, however you call it. But anyway, I did want to stress the fact that we're making progress. It's kind of piecemeal progress. If I understand correctly, the settlement in New York prohibits use of solitary confinement for underage inmates. Even for young adults, it includes a certain form of restrictive housing that amounts to 5 or 6 hours a day at least in social contact with others, which is a big improvement. And the settlement in the class action litigation in California is wonderful, because in California they were putting people in solitary confinement on the basis of a categorical determination that they belong to gangs, without having had or belonged or are associated, not even being members of gangs, without any reference to any specific conduct or behavior of the person. And the state of California determined that you were associated with a gang because you had a certain tattoo, or because you had literature that they thought, or even drawings that they thought associated you with one of the gangs. And I know that the gang problem 10 or 15 years ago in California was a very serious problem, and that California had to do something to protect its general population in prisons. But in this settlement, California has agreed that about 90% of people who are in solitary confinement in California are being taken out of solitary confinement because there's no reason for it. So my impression is that we're making progress. But by the time we get to countries like Japan and China, where the actual way in which you serve a long prison term is solitary confinement, we're going to have to do a lot more to that, because as we were saying, you're already serving time. What is the need for additional punishment? But I want to stress that short-term solitary confinement or isolation is an important tool of prison discipline. But my sense is that it has to be meted out in regards to specific behavior, not categorization of persons.
Okay. I do want to talk a little bit about Guantanamo, since we have a leading expert on Guantanamo here, two actually. But I want to ask Dr. Crosby a little bit. She's told me she can't talk about some things because she does have top secret clearance. Yeah, there's all this spy stuff. But I know, but there are some public cases she's been involved with. So can you tell us a little bit about the Diab case and the role of the physician in that case?
The Diab case, certainly. I can talk about only what is in the public record.
I shouldn't laugh at this. This is actually quite serious.
So, and I'd be curious to hear Professor Mendez's commentary on this case. I don't know if you're familiar with the Diab case. He was actually the first Guantanamo detainee to successfully bring his complaint about force feeding to federal court, heard by Judge Gladys Kessler back in the fall of 2014. And ultimately what he was protesting is that the act of force feeding, he was on a peaceful protest for unlawful detention and his allegation of disrespect of his religion, and was forcibly extracted from his cell twice a day by an extraction team, which is these gentlemen, know about the extraction teams probably better than I do, but they are a force of 6 to 8 large people in shields and helmets, and they actually storm into the cell. They take the prisoner down and actually carry him out. So it is associated with quite a bit of force, injuries. It's painful, it's humiliating, it's degrading. And he would be taken to a feeding chair twice a day. He would be strapped into the feeding chair and be fed through a nasogastric tube, liquid meals twice a day. Judge Kessler heard the case in court, and despite the fact that, it's hard to believe, she ultimately did not rule in his favor, in that he did not meet the level of deliberate indifference, and which was very disappointing, although she did talk publicly about the shameful way that he was given medical care and the shameful way Guantanamo treated him. I think one of the most...
The case was tried on the basis of the Eighth Amendment instead of international human rights law and the Geneva Conventions, which was a mistake.
Which was, right.
But that's different.
I think the important point that this case illuminated and made public was the important role that health professionals played in the treatment of Mr. Diab. And they were complicit in actually, they directly took away his comfort items in an effort to punish him for being on a hunger strike. Mr. Diab was paralyzed. He couldn't walk. He literally had to crawl on the floor. The doctor took away his wheelchair and his crutches, as well as other comfort items.
Like what?
In fact, we have doctor's orders. The doctor actually took away his underwear and his socks in an effort to punish him. And I think this really let us understand how clinicians became caught up into this culture of punishment for being on a hunger strike and really became part of the guard force. And they completely lost their therapeutic relationship with the patient. So when they then tried to help Mr. Diab and evaluate him for his paralysis, he didn't trust them, and he wouldn't let them get near him or do anything. And you can understand that. Here on one hand, they were punishing him, and then they expected him to trust him to take care of him. So you can just see how this cycled and how this system was broken, and how doctors were very complicit and directly involved in punishment. And in my opinion, his treatment during this hunger strike did rise to the level of torture. And a lot of that had to do with the forced cell extractions that happened as part of the force feeding.
And what happened to him? Where is he today?
So Mr. Diab was transferred out of Guantanamo shortly after his trial to Uruguay, and a Spanish-speaking country where he had no roots, no ties, didn't know a single person, and has really struggled there since his transfer. He's not yet been reunited with his wife and his children.
Didn't he go on another hunger strike in Uruguay? Am I wrong about that?
He, like, as I said, he's really struggling. He actually asked the U.S. to help pay for his treatment and restitution, and did go on protest outside of the U.S. Embassy in Montevideo, but he hasn't received any treatment or restitution. So this is when I get into talking, what obligation does the U.S. have, to transfer somebody like this who's been detained without charges for 12 years, has suffered torture, has PTSD, has other mental health and physical health complications of his torture, and then is simply transferred to a state where he has no ties.
So what do you think, Juan? What obligations does the United States have for rehabilitation and restitution in a case like that?
Well, I think because transfers even to countries not of their nationality of the detainees is the only way to relieve the prolonged and arbitrary detention of these people. I don't want to criticize transfers. I think Uruguay, the president of Uruguay made a very generous gesture, even though it kind of relieves the United States of its responsibility to some extent. He did it on humanitarian grounds, so I don't want to criticize the transfer to Uruguay or to any other country for that matter, if it is the only way to get people out of Guantanamo. What I do think, however, as I said before, is that if Mr. Diab requires rehabilitation services and even reparations, the United States has a fundamental legal obligation as a signatory to the Convention Against Torture to provide for those services and those reparations.
Okay. You also said that prisons have an obligation to keep, essentially, to keep their prisoners alive. Is that right? David, I'd like you to talk
them from violence
about the
as well.
Latif case a little bit, if you
Sure,
can.
yeah, and
This is another Guantanamo case.
another Guantanamo case, and just as a disclaimer, I've never stepped foot on Guantanamo. On the other hand, I can talk about whatever I want. So this is a case that I studied a few years ago. There's some limited information about exactly what occurred, but the basics are that a detainee in Guantanamo was found dead in his cell in late November of 2012. He had ingested 24 tabs of an antipsychotic medication called paliperidone, also known as Invega, and and then he was found dead. They tried to resuscitate him, but he wasn't. He was pronounced dead soon after that. The case itself is of a prisoner suicide. It's one of the things that a prison or jail, especially jail and especially lockups, because there's a little bit of a higher incidence of suicide among some of the shorter stay facilities, and that preventing suicide is one of the most important things that any sort of institution like this needs to kind of have at their forefront, from the beginning, knowing that simply being incarcerated, it puts you at a significantly higher risk for suicide. And in this case, it sort of brings a little bit of, when thinking about human rights, it brings a little bit of the comments about the Eighth Amendment that were brought up earlier. There's some case law, and again, I very much want to disclaim I'm not a lawyer, and please correct me. I'll have the lawyers correct me a little bit later if I'm wrong about this, but
That won't be a problem.
it hasn't been for 42 years. So and so there's a case, I think it was Estelle v. Gamble, that basically said that if you're, at least in the United States, if you're the medical care to an institutionalized person rises to the level of deliberate indifference to that person's individual needs, medical needs, then it becomes it gets to the point where it's actually a violation of the Eighth Amendment, which doesn't mean a prisoner or someone couldn't sue for malpractice, but it just meant that it actually gets to the level of cruel and unusual punishment. And then I think it was a little later in Farmer v. Brennan where the specifics of what does deliberate indifference mean, and then they came up with the mens rea of subjective recklessness, so that you'd have to specifically know that one person had a specific need and deliberately disregarded it, and then which led to some injury. This case, in most cases of suicide, and the cases that I've been involved with in general, and not that I was involved in this case at all, but in cases of malpractice for jail suicide or prison suicide, often the attorneys will try to, plaintiff attorneys will try to ask us, does this rise to the level of deliberate indifference? And usually it's very unlikely that it does. For the most part, it's kind of hard to really be that deliberately indifferent to somebody who ends up committing suicide. It can be malpractice, it can be institutional malpractice, medical, it could be a lot of different things, but sometimes it's hard to rise to that level. Going back to this case, it's, again, we don't know all the facts exactly what happened, but there's so many, when you look at this case and exactly what happened, there's so many levels where there was a breach of somebody not doing what they were supposed to do or not following a protocol, not following a procedure, that there's a long chain of events where if at one point anyone stopped and said, okay, we need to redo this, we need to research this guy's cell, we need to do something, any of those interventions could have easily prevented this from happening when you look at how many different things led to this. And so the man and I, this is all a little bit from memory because I know I was going to present this again, but my understanding was that he was detained in around, I think it was pretty early on, like 2002 or something. He was a young man with a history of a traumatic brain injury and some unilateral hearing loss, and he was seeking medical care at some point. He was probably coerced by the Taliban to join some fighting, and he was involved in one. I think he took up arms at one point, but he didn't fire a weapon. But he was involved with something like that. And so when he was captured, he had said, "I was seeking medical care." And then I think that there's this common cover story of folks saying that they're seeking medical care when they're getting involved with terrorism acts or something like that. So, which he probably actually was seeking medical care, but they sort of, when he was captured, they weren't buying it basically. So he ends up going to he ends up in Guantanamo. He fights his case, wins, I think, in the district court, a habeas petition, and then then it was appealed, and then it was reversed in the circuit court, and then he was appealed to the Supreme Court. The Supreme Court denied and wouldn't refuse to hear the case. Throughout his stay there, it seems like it's hard to know exactly what his diagnosis was, but he was diagnosed with bipolar disorder. He also was diagnosed with borderline personality disorder, and there are a lot of issues in psychiatry where there are folks that have borderline personality disorder that's very severe, and sometimes they get categorized as bipolar disorder when it's not really the case. His case, it's not clear. He may have had full-blown bipolar disorder, and I've not been able to look at his records or anything, so I'm not exactly sure. But he had this history of a lot of acting out, a lot of getting in trouble, throwing feces at guards, and, throwing rocks at a bunch of other things. He had a history of self-harm, cutting himself, a lot of cutting, and many suicide attempts. It's hard to know exactly how many, but he had a particular history of, at one point, hoarding medications and then showing it to the chaplain, I believe, and saying, "Look at this, I could just take this whenever I want." A lot of very provocative, behavior, the stuff that really gets under the skin of people that work in prisons, things like this. This is a really difficult guy to work with, or to get anything done with, and so he was sort of like seen as a troublemaker to some extent. So so very, very long history of self-harm and things like that. He and what happened?
I don't want to go into the long history.
Right. So
just tell me, how do you prevent him from committing suicide?
So what happened? Yeah, and so let me wrap up with exactly the steps that led up to this. So he was got in trouble for, I think it was breaking lights and then throwing feces on one of the COs. He was sent to, but the psychiatrist said he looks like he's unstable. You need to send him to the behavioral health unit to get treated. So he goes to the hospital to get treated. He's there for, I think it's like, I don't remember if it's a week or 5 days or something like that. So he's there. During that time, he hoards the medication. And basically looking at the timeline and when he was prescribed the medications, we know that he hoarded this many tabs of paliperidone during that time. So then they said, okay, if he's done with his time in the hospital, and there's this big debate, should he go into solitary to serve his time? It's sort of like serve as punishment for this. And it looks like the psychiatrist had said something like, his actions were deliberate, so he should serve the time. So they transferred him to the punishment unit, I think it's called like that, in Camp 5, I think, and he and put him in there. That night is when he ingested the tabs. And if you look at the history of everything that happened, you have policies here that have policies of searching cells when someone's transferred. So you search cells, search belongings. Policies of giving medications, and even routinely you give medications to someone. You do mouth checks to make sure they swallowed it, make sure they took it, and if they refuse it, they can still refuse it, but you don't just leave it with them and let them do whatever they want with it. You take it, you document their refusal and you put it back. Clearly that was not done. At the time of his death, they actually had a cup of his pills just sitting there in his the little slot, for him to get whenever he woke up. When he was in there in the cell, he was put on line of sight, electronic and visual. So electronic being there's a camera in these cells, and so someone's observing him all the time on a camera, and someone else is sitting outside looking through the window and observing him. And during that time, he ingested all these tabs, but no one saw it, somehow. They interviewed the guards, and a lot of it's redacted in the report, and they say, well, we never looked away for more than 6 seconds. Very hard to believe. Not saying it's impossible, very hard to believe. He started acting really strange, jumping up and down, smeared the camera with cornflakes so you couldn't see electronic line of sight. But they didn't stop and go in there, clean the camera off, or whatever the hell they needed to do. They just were like, okay, we'll just leave it. Someone else was looking at him. And this is also going back to the pills. He literally had a specific history of hoarding pills himself. So if you want to say it's not foreseeable that this person someone could have hoarded pills, which it obviously is, he specifically did. He specifically had a history of that. And then we don't have the full details of his death or the cause of death, at least at the time of this report. And he looks like he had some vomiting on his. He vomited at some point, and then he had aspiration, probably some aspiration pneumonia, or he aspirated some of it. And at the same time, you have guys that are watching this guy and don't hear him vomit. You know, there's so many different things like that, because eventually he's lying there for hours and hours and hours, not making a sound. And this guy's got a history of poor sleeping. He snores horribly. So his buddies are calling him to get up for prayer call, and he's not going where he normally does go. And so all these things happen. It takes a long time before anyone even opens the cell and goes inside to check.
So who would
check
you
on him.
blame for this? Who's responsible? I put it that way.
Well, I think that from what I could tell from this situation, the way I look at it is that on the one hand, you have a lot of procedures and policies in place
But you're not following.
that are not being followed. And so you have those individual breaches of that. But you also have a system where on a typical day in a typical prison, I imagine if you really looked at every single, policy at every moment, you probably, just randomly do an audit, you're probably going to find some breaches. And that's not necessarily, I'm not going to criticize that because it's practical, it happens. But usually within a system, there's some sort of fail-safe. You have a good supervisor that someone checks in with, or someone isn't sure what's going on, and they say, well, we never really checked this guy's cell completely, or we didn't, ask him to open up the Quran to see if he was hoarding anything in that, or something like that, where someone at one point could have said, let me stop and ask my supervisor what to do. Let me do this, let me do that. And it looks like nobody did that. And it seems to me that there's a culture of no one being comfortable doing that either. So all those things together put make a very, very difficult system to properly, almost to the point where an outcome like this is almost inevitable. And also you have folks that are dealing with a guy that's really difficult to deal with, that causes a lot of emotions in people that are understandable. These people a lot of these guys probably hated this guy, especially the people that were assaulted by him. And if you get to the point where you just want to retaliate against someone like that, then that's the point where you really need to step out. But you also need a system where you can have a team of people that are supposedly treating this guy together, process this, and understand what's going on. And also some other things where this guy was also he was very manipulative, and you got people to give him extra things, have a blanket when he wasn't supposed to have a blanket, and a lot of different. It's interesting how he's the kind of guy that got everybody pissed off, but he also had ways of getting people that do favors for him too, and so it was.
So,
it was
Dr.
a lot
Crosby,
of
is he
things, yeah.
unusual? Was that an unusual prisoner, or is that typical?
No.
Unusual. Yeah,
for a guy, I guess no. I would not say
You
it's
wouldn't say-
unusual.
But I
actually.
want to ask Dr. Crosby.
Yeah. Oh, in Guantanamo? Yeah.
Is he unusual? Being manipulative of the system, striking
No,
out?
I think this is typical. You have a group of men who were probably vulnerable to begin with, right, to be in the wrong place, wrong time, picked up. And they're here for 12 years, and most of them have suffered enhanced interrogation techniques. They're being held without charge. And I would say that I would give an opinion that most of them do have mental illness, and not to this degree, certainly, but absolutely, it's not unusual.
And how well are they treated for it? How good is the mental health care at Guantanamo?
Mental health, physical health. I think, again, this Latif case that Dr. Annis outlined for us is really an example of a larger problem at a place like Guantanamo and the right to health. Guantanamo is an isolated place. There are not sophisticated means to take care of psychiatrically ill patients like Mr. Latif. My gentleman, Mr. Diab, who is paralyzed, there's no MRI machine, for instance. There is no advanced, sophisticated psychiatric care, really, there. And what is our obligation in those cases? Because Congress has passed laws that we cannot transfer people to the mainland for medical treatment. And I'll tell you, we've petitioned for a lot of Guantanamo detainees to be transferred to the mainland so they can get their cardiac stress test, so they can get an MRI, so they can get whatever medical care that is necessary. And our state has the capability to provide that care. We just have laws preventing it. And this happens over and over again at Guantanamo.
One more comment, then I want to open it to the audience because you guys have been very patient. You've been very patient. Go ahead, Brian.
I have a question / comment. I'll restrict it to just a question, mostly directed to Dr. Annis, but then the rest of the panel as well. Not to get too far into the weeds on the ins and outs of psychiatric med management, but in retrospect, would this have been an appropriate case in which to consider injectable alternatives such as Invega Sustaina, which is a direct alternative to the oral medication he was taking? You give that intramuscularly about once a month or so, right. Or there are also other similar medications that are available by injection. What are your thoughts on that?
So that was considered with him. And it might have been Consta, but in general, right. It's the same thing. Let's be real. So so he was considering allowing that because he sometimes would take his meds, sometimes he wouldn't, even before they realized he was hoarding it. And as an aside, it's not very funny, but there's this point where 5 days into the prescription for this medication, he says he's feeling great and there's no side effects. It's like, well, it's because he's not taking the damn medication. But so there was this. They've been trying to get him to do that. He wasn't quite sure about it. He wrote a letter to his lawyer. I think the topic was on that, about whether he should take it or shouldn't, which is interesting, asking your lawyer for medical advice. But sometimes it happens. And there was
better than the advice he was getting from the doctors down there.
In this case, that's correct. And so what happened was, at the same time, there was this, I think that there's an ethics committee at Guantanamo. I'm not sure it's literally at Guantanamo or if it was within the in CENTCOM or something, where there was a committee that came together to recommend whether or not he could either start the process of being forced to take the injection. And I think that they had either recommended it or not before, and by the time that went through, this had already occurred. So the details of that I'm not exactly sure, and what exactly the process is for forcible treatment in that case. I'm not sure, but he was being considered for that, for sure.
Okay, now we're going to open it up. Where's our microphone people? There we go.
Is this on? Okay, go ahead. Winnie Roach from the School of Public Health. So this is a question for all of you, because as I'm listening to the different scenarios and cases and the contexts, is it ever possible for a prison to be run within a frame of human rights, or is it naturally such a contradiction between the goals of a prison and any human rights the way that we conceive it or define it, that it has to go one way or the other? You can't meet both.
Please, yeah.
I think it's definitely possible. I mean, obviously, the question of the abuse of incarceration rates, turns the whole, administration of prisons in the wrong direction. But international law recognizes that some people have antisocial behavior and that the state has a right to prosecute and adjudicate against them, including with prison terms. The only thing that international law requires is first due process, so that nobody is incarcerated without having a chance to challenge whether he should be there or not, and two, treatment conditions. The standard minimum rules on the treatment of prisoners is, let me stress, it's a non-binding document, but it's a very authoritative document on what prisons should look like. And yes, it's ideal, it's a gold standard, but it's not unattainable. I mean, I don't want to say that everybody should have prisons like Sweden that are country clubs, but I am saying that it is possible. And interestingly, countries that have country club prisons have them almost empty because they have a very low crime rate. It's, it seems counterintuitive, but in fact, the Netherlands, half of the, the prisons in the Netherlands are occupied only at 50% of capacity. And of course, they're not in a hurry to fill them either, like unfortunately in some other countries we are.
Professor Mariner and Brandon and I were talking earlier, and we were on that topic. And one of this is just sort of, this is kind of an aside. It just made me think of this though. But there's sometimes a question of what's the level of care you're supposed to get in a facility, inside a prison or a jail, and different organizations come up with some different, somewhat different language, like the American Public Health Association and our group, the American Psychiatric Association, and ours, I think, is that the level should be at what is available in the community. Doesn't necessarily mean what people get in the community, but what's available in the community, which almost suggests there should be a higher standard for mental health in prisons. And one of the things that's sort of interesting too is that you kind of should be better at diagnosing mental health in a prison, because the person's there 24 hours. You have COs, you have nurses that see the person, you see doctors that see the person. So if they weren't diagnosed with a mental illness before and they have one, you have much more of an opportunity to observe them, much more an opportunity to intervene, and putting aside the folks that want treatment versus the ones that don't. At least let's say the ones that do, you're going to actually be in much better position to do that. So in a sense, their standard maybe should be higher even in that sense, as far as how you can treat prisoners and how you can both screen and identify mental illness as well as treat.
I would just add one additional thought on the topic of your question, that in addition to remembering that states do things differently and we have different terms for different kinds of things, most states, I think, have a hierarchy of all the way from maximum security, which has been the majority of mine and Dr. Annis's experience in the New York State system, all the way down to medium, minimum security work camps. But it's interesting, in my anecdotal experience, not all prisoners, you would think intuitively that they would just want the lowest security level possible during their stay. That's certainly true of many, but then there are other people who say, hey, the medium security status quo in this state is dorm style housing. So that's kind of being like at a summer camp with other felons. You can't watch your stuff. Who's in the bed above or below you. I'd rather just have my own personalized cell in a maximum security setting. So I would just point out that even within each individual state, and there is some due process that attaches to this as well. There's some review body that decides what level of security and the harshness, I suppose, of the prison that is appropriate for each offender. And over time, they become eligible for transfers to a lower level and that sort of thing.
I agree that individual cells is preferable to dormitory kind cell blocks. But it really depends on the treatment. I mean, if you're going to be 24 hours a day locked up in your cell, I think the ideal is individual cells with as many hours as possible of interchange with others in a controlled setting, open cell blocks, going to the court, the yard, being able to practice sports or to do work therapy, all of that. I mean, it does require investment by the state, but it's not impossible, and there's a lot of experience on that, and there's a lot of very capable people who have gone through administration of prisons and know how to do these things. I think the worst problem, well, maybe not as bad as solitary confinement, prolonged solitary confinement, but very bad is overcrowding. And in many countries that I visit, the prisons are inhumane because they are so overcrowded that people cannot take care of themselves. They are constantly at risk of being, suffer aggression, or there's predators all over, and they are completely unsanitary. You have one toilet for 45 people, and obviously you don't want isolation, but you also don't want the kind of overcrowding There are prisons in Brazil, for example, and they're really jails, not prisons, but they spend so much time in places that are so overcrowded that people have to sleep in hammocks. And they can't get out of the hammock because there's no room. And so a doctor friend of mine who comes with me to visit prisons, I didn't visit that one, but he did with my predecessor. And he told me that some of these people already have their muscles deteriorating because they can't get out of the hammock for literally weeks or months at a time.
I've been waiting all day to ask, but now the conversation has shifted towards it, which is great. So can you just give us a sort of human rights perspective or human rights lens through which to look at the American situation, which is as follows, as I see it, where you have a mature, stable criminal justice system with incarceration as its frequent end product, but where that system is not only contributing to, but deepening intergroup differences, right? Where you have such disproportionate incarceration rates between, let's just talk about racial groups for a second, black, white racial groups, that the system itself is contributing to these intergroup differences. So what does a social justice or human rights framework tell us then about the validity of that system and what we should be doing towards thinking about changing that system?
Yeah. Well, I think you can say that the purpose of incarceration under international human rights law has to be rehabilitation, and not in the medical sense, but rehabilitation of an offender and to be able to reintegrate him or her into society. When that purpose is lost, the system starts breaking down. I don't think beyond that we can say much more from the international human rights perspective, again, except for the questions of due process and of fair trial that may lead you to prison, but after a fair trial, and then on conditions. But beyond that, I don't think international law can contribute much as to, in the sense of what is the level of incarceration that is appropriate to a society. Here is where democracy and political participation has a lot to say, and unfortunately that means that in some societies that believe that they are beset by high levels of crime, the public opinion unfortunately goes in the wrong direction, and public opinion wants the state to incarcerate people and throw away the key, and they don't care what happens inside the prison. As your question suggests, it's completely self-defeating, because if we want to have to control the crime rate in the overall society, the worst thing that we could be doing is having these kind of schools of crime that don't rehabilitate anybody, but in fact, if anything, they make people who made a mistake in their life now being only able to go out and commit new crimes and to commit them in a more and more violent way. So I think there's a very good argument. Unfortunately, sometimes it falls into deaf ears, especially because politicians all over the world, and I'm not talking now about the United States, it's so easy to get elected to office by offering to solve crime rate by having a hard stance on crime and putting people away, that it's very difficult to fight this trend towards harsh policies, even if you can make the case that they violate human rights.
What about a clear disproportionate application to marginalized groups, deepening the marginalization, and resulting in widening social divides? I hear what you're saying. I hear what you're saying about application to groups that are violent. Right. There's no evidence anywhere that particular marginalized groups or minority groups have in any way are committing crimes at a rate that is commensurate with the disproportionate incarceration, certainly in this country. So does that provide a lever and a tool to which to tackle the system?
Yeah. Well, of course, I should have said also that the international human rights law does establish one other parameter, that is that the law has to be applied without any form of discrimination on the basis of classes, suspect classes like race, religion, national origin, sex, gender, etc. Of course, international law does, bring in a limit. But the science may be there, the social science may be there to prove that the incarceration rate for certain racial groups and even age groups is disproportionate to their participation in crime. But go convince a populace that that's the case. I mean, people automatically feel, well, yes, these people are disproportionately represented in the prison population because they disproportionately commit crimes. And it's very little that you can tell them in terms of statistical information and all that will persuade them otherwise. Nevertheless, I of course think that we have to fight this battle in all of those fronts, not just wave the Universal Declaration of Human Rights at people. We have to fight we have to say first and foremost that torture and cruel, inhuman, and degrading treatment are immoral, and that's why they're illegal. But then we have to say why it doesn't work, or that why it creates a political cost that far outweighs any benefit that we can get from it.
Thank you. I believe that in the U.S., an increasing proportion of jails and prisons are run privately. Are you aware of any differential in the human rights records in one versus the other managed categories of those facilities?
No, and I think the use of private jails is expanding into other parts of the world. In my visit to Brazil, I visited one private jail, and I have to say, reluctantly, but it was better than the state jails, prisons actually. It
doesn't say much.
It doesn't say much, but well, in this case, it was relatively new, carefully controlled, so that this was a company that had a contract that allowed them to say, we don't want any more prisoners. State prisons don't have that luxury of telling the state, don't send us any more because we can't hold them. But anyway, I don't think there's anything particularly wrong about using private jails if the state continues to bear the responsibility for who is there and for their rights. What I understand, and I have only anecdotal evidence about the United States, I haven't received too many complaints in order to give you a more complete answer. But what I understand is that in the United States, both at private prisons used in state criminal justice systems, but also in immigration detention, where it's very widely used, what happens is they start with a contract that says you will be responsible for this many people, and you're going to have to invest this much to take care of them. But then either they take in more people, or they start cutting costs to maintain their profits, and therefore the disciplinary process breaks down. First the disciplinary process, and then the services themselves break down as well. Now, again, unfortunately, this is mostly anecdotal evidence, but it stands to reason that if you're a company and you're making a lot of money, and there's there seems to be a lot of corruption around it as well, because these companies also lobby very hard and make state legislatures and even Congress be much more amenable to private detention, private prisons. But beyond that, if you are trying to maintain your level of profits, the adjustment variable is cutting costs. And if you cut costs, you cut services, and you cut maintenance, for example. And pretty soon you do have a problem with training of the staff, with facilities themselves, with the sanitary conditions of the prisons and things like that.
My name is Olivia. I'm an MPH student, and my question is about sexual violence and sexual assault, specifically in prisons. And if it's not being prevented or not being addressed, would you put that in the category of torture or in cruel, inhuman, and degrading punishment? And what is the responsibility from a human rights perspective to address that?
Well, I mean, sexual assault is a form of torture. If it happens by guards, it's torture, period. If it happens in prisoner on prisoner violence, the state is responsible for the protection of everybody who is incarcerated. So the state, this is one of those occasions in which non-state actor torture engages the responsibility of the state. Now that's the easy case because in a controlled setting like a prison, and with the assumption that the state is responsible for the safety of everyone who's incarcerated, then of course the state is also responsible for the actions of non-state actors that commit sexual assault. But under the same token, we consider rape or sexual assault forms of torture or cruel, inhuman, and degrading treatment even when they happen in the street and by non-state actors. But in those cases, under circumstances in which the state knows or ought to know that a person is vulnerable to that kind of assault and refuses to protect him or her. So domestic violence, again, in those circumstances, is a responsibility of the state under international law. But it's even easier in a prison setting because the state knows who is, or ought to know, who is vulnerable to that kind of assault. So yes, it is a human rights violation under all circumstances.
I was just going to bring up a case not too long ago in Connecticut that I was involved in. And this was a case where a man was being punished for being on a hunger strike and put in solitary, but put in solitary with a known sex offender. And he was sexually assaulted, known to the prison officials in prison. And absolutely, that would rise to the level of cruel, inhuman, degrading treatment and torture. But again, getting back, you're in prison and then you're being punished while you're in prison.
Yes, I would just add a couple of things. One, I think this would be nationwide because it was a federal law. They're signed into law by former President George W. Bush, either in 2003 or 2005. The Prison Rape Elimination Act, or PREA. So at least in my experience in the state of New York, under that federal law, once a prison worker becomes aware of an allegation or a report of sexual assault or abuse, there is a standardized administrative process by which we go about alerting our own authorities internally, then triggering an investigation out of Albany. I would just follow that up as well by saying that the person who's disclosing that abuse to us is not always happy with us, but we have to explain that we're following the law. The second thing I would
get reports?
What's that?
You get a lot of reports?
I don't have a great way to quantify how many disclosures I personally received. The other flip side of that is that if there is a disclosure made to me that's already been disclosed to someone else and there's a process already underway for that same incident or that same episode of abuse, then that may not invoke the same. Basically, if someone's already reported it, right? But just the second thing, that the question of keeping prisoners safe from sexual abuse and assault, let's, for the sake of argument, say from other inmates, does again invoke the questions of the purposes of confinement and exactly whom you're confining, right? So if you're confining the person who is perpetrating these assaults or posing that risk, then that would often be either solitary confinement or administrative segregation. But if you're looking at it from the other end and identifying someone who would be particularly vulnerable to that assault before it's happened, then you might administratively segregate them or put them into protective custody kind of prophylactically, but it may still impinge their liberty interests and their freedom of movement further than general population.
Well, one of the first cases that I worked on solitary confinement, beyond the Manning case, involved immigration detention of LGBTI people for deportation purposes, and they were categorically, in some places, obviously, put into protective custody without their even asking for protection. So, and the protective custody was amounted to solitary confinement.
Just one more comment that comes to mind. We've been talking about Guantanamo. Sexual assault was not uncommon in interrogation techniques, and that is sexual assault with instruments. And as Professor Mendez alluded to the Senate report on torture, men were also assaulted with rectal tubes under the medicalization of rectal rehydration or feeding. So not an uncommon thing.
I'm going to use the cards one more time. How many people know about the Senate report on torture that we're talking? The Senate report on torture. You either know about it or you don't. If you have, you can find your cards. Green. Okay,
Green.
not quite half. Okay, that's sad. I mean, that report should have, really awakened the American public.
Yeah, I'm
I thought it
surprised.
would.
Leonard has a question.
Yeah, we got one more here first, then Leonard, you're next. Yeah, go ahead.
Hi, I'm Edie. I'm staff at the BU School of Public Health. And I have a question about how torture is defined, not in terms of the acts that are committed, but who commits them. I'm thinking specifically of the people who have suffered from gang violence in Central America and come over the border illegally into the United States. Would they be considered victims of torture? And if so, are they protected, at least in theory, under non-refoulement?
Well, the definition requires a state actor. The definition of torture requires a state actor under the convention, but it's a state actor who is a perpetrator or who acquiesces or tolerates torture. So that's why, under certain circumstances, we can find a state responsible for torture committed by a non-state actor under the circumstances that I already mentioned, that the state knows or ought to know and refuses to do something. Because in those cases, they are acting in acquiescence or tolerance of torture committed by others. Now, I think it depends on the case. If people have been violently attacked by gangs, it depends if in Honduras or El Salvador, the state is doing something about it or not. So you'd have to, you can't say categorically that's torture because of the violence that has been committed, but you have to also add these other ingredients. Either way, however, if they are already in the United States and seeking asylum or whatever other protection, and there's a very high risk, and you can show there's a very high risk that if sent back to Honduras or El Salvador or Guatemala, they will suffer gang violence, you may have a very good case for non-refoulement, either as asylees or non-refoulement of the Torture Convention.
Professor Mendez, you used the term responsibility a number of times, that it's a state responsibility. And what you summarized very well, the Senate report on torture. There's no doubt that we tortured people, right? And you talked about solitary confinement. The maximum security prison in Florence, in Colorado, everyone's in solitary confinement. They're sent there for the rest of their lives, not because they're particularly dangerous, because that's their punishment. They spend 23 hours a day in a cell, just as a matter of course. So that's torture. Does it matter? So this is torture. So it's torture. So is there anything that could be done? You know, one of the things you want law to do is to keep people from doing it again. So one is that you pointed out that there are some countries that say, well, the United States tortures people, why can't we? You know, we have someone who might be a presidential candidate saying, if you think waterboarding was torture, wait until I get into the White House. I'll show you what torture is. That there is no sense at all of responsibility. So are rich countries like America immune from being responsible for the torture that they inflict on others?
Yeah. Well, I use the word state responsibility as a term of art in international law because international human rights law is all about state responsibility for the treatment of its own citizens. And it is state responsibility to the outside world, to the international community, and to other state responsibility for the treatment of its own citizens. And it is state responsibility to the outside world, to the international community, and to other nations as well, even though it is about people who are inhabitants of the same state. Now, of course I can say the United States is responsible for torture in the case of, solitary confinement of Bradley Manning, for example. Now, but your question is, so what? And what happens next? And unfortunately, what happens next is related to the relatively weak and infancy of international law. But international human rights law is no less weak in enforcement measures than general international law is. You know, states can invade other states and get away with it. That doesn't mean that they're not violating the law. They are, but we don't have means of enforcement against it. Or we have weak means of enforcement, let me put it that way. So what Mr. Puras and I do is we are perhaps even the weakest link of the enforcement methodology of international human rights law, because some states can come before the European Court, for example, or the Inter-American Court, and can be, with binding resolutions, told you have to pay reparations and you have to release this prisoner, etc. We are strictly non-binding, and so states can and do consider what we say in the nature of recommendations. On the other hand, if we get our facts right and if we do the analysis right and we can be persuasive, convincing, we can generate conditions under which the civil society and the polity of the country that violates human rights can help turn things around. And I think the progress that I mentioned about solitary confinement, it is progress and it's only initial progress, and there's a lot more to be done. But it is an example of that. I mean, I feel that I have contributed. I mean, obviously I wasn't the only one talking about solitary confinement in U.S. prisons. But my report in 2011 fed into a process that included litigation, but also advocacy, and the Senate holding a couple of very important hearings, and more recently President Obama calling attention to how infamous this solitary confinement process is. And so in that sense, we, the special rapporteurs, make a contribution, but ultimate change, unfortunately, or fortunately or unfortunately, has to come from within, and we can only hope that we can, some way participate in that process.
Hi. I don't know if I'm kind of dialing back a little bit to the questions that we were discussing on mental health, and I don't know if this is a little bit off topic, but you guys are talking a lot about how you were going into these prisons and mental health patients, specifically the one you were talking about in Guantanamo who ended up committing suicide. There's all of these markers. is this something where we need to look back and say, like, why are they in prison to begin with? I mean, obviously, there's, terrorism is like a pretty scary thing, but, with some of these patients, like, are they better off in sort of an institution? I know we deinstitutionalize everyone, but, like, is that something that we should be thinking about in terms of focusing more on treatment rather than putting them in prison and then deciding whether or not to put them in solitary?
I'm going to maybe briefly comment on that. It's a very, very good question. So the question of why they're in prison, at least the way it kind of works in the system, the way I understand it, is that if somebody commits a crime and then they're mentally ill at the time, they have the option of putting forth a defense, not guilty by reason of insanity. And if they're successful, then they do go to an institution. And it's indefinite to some extent. If they're dangerous, they'll go to a forensic hospital, secure forensic hospital, and then be stepped down into a civil hospital, and then be stepped down into the community. So there's a process for that. But then there's when it comes to mental health, one of the big issues is folks that have a serious mental illness that probably contributed to them being vulnerable to either being caught or getting caught up in something or coerced, and they're just kind of stuck in the middle where they don't have a valid insanity defense or don't want to take it, which is not always a good idea, by the way. I'm not trying to say that it would be, but let's just say that there's a component of vulnerability of something that they had that actually did lead to some extent them being arrested for a certain crime. So once they've been sentenced, they're in prison, and they start decompensating. They start getting to the point where you're not able to treat them kind of in that setting. In those situations, we do transfer, at least in New York, we transfer folks to secure hospital until they're kind of stabilized, and then back to the prison. And it's kind of like parallels to some extent someone in the community. In a sense, you're in the prison community and like in the community, and then you go up to a higher level of care if you need it, and then once you're stable, you go out. The same model in a sense that you would be in the community. You're in the community, you're unstable, you go to the hospital to get stable until you can get back into the community and back outside the hospital. That's the way, at least, the system kind of works in that situation. As far as Guantanamo, I definitely want to defer to our expert here about how many of those folks really should have been arrested in the first place, or what the numbers are when it comes to a certain amount of those folks that maybe literally were just picked up without any justification too.
My anecdotal experience is certainly we don't have adequate resources or the capability to treat the mental health ailments in Guantanamo and other military prisons. And the other thing that's become really clear to me is our utter lack of cultural competence in understanding and treating mental illness in other cultures. So I think we've failed in that context, for sure.
Just to add to what Dr. Annis was talking about in terms of the general case of mental health and prison, a lot of this varies state by state, even county by county, but there are some mental health courts in the city of New York that do try to divert people who have mental health issues into a different track, focusing more on treatment rather than incarceration. But then there are also, I correct this if this is wrong, but Doug Mossman out of Ohio has done some research suggesting that if you give the average person a choice between, let's say 20 years flat for murder versus indefinite hospitalization for an insanity defense, that many people would view the definite incarceration term as less injurious to their liberty than, who knows when I'm getting out of this state psych hospital. So that's, an interesting thing to ponder as well.
Point too, for like a shorter sentence. For 20 years, I don't know. I think a lot of folks might go to the hospital, but for 5 years or something like that, often these folks, well, they might be going back to the proverbial hood or whatever, and they're thinking, yeah, I just got out of prison, check me out, and they're all get some cred, getting out of a hospital, like, oh man, mentally ill guy, that doesn't really help your street cred too much. So I mean, there's even some factors like that about what sometimes people will choose. And then there's folks that literally, like the folks that just won't take parole no matter what, or like a sentence that has parole added to it, or for lower crime to take probation. They just can't stand the fact of someone outside, making someone check in that they might find humiliating, or following these rules, and just can't stand it. And they say, just let me do my hard time. I'm out. I'm free. So a lot of folks want that definite, which is understandable too. I know we might be drifting a little bit off topic, but
just one more thing that one of the most common things that Dr. Annis and I were involved in during our 1 year of training in our forensic psychiatry program in Syracuse was competence to stand trial, right? So that's another issue, and you could debate and talk about how serious mental illness may impair one's ability to contest the state relative to other kinds of disenfranchisement, race, poverty. But in terms of the thinking about what part of the driving force is behind the overrepresentation of serious mental illness in our state and federal prison system, I would imagine that would be another large part of the conversation, in addition to the mere lack of institutional beds we used to have, is that there may be people who are even more impaired in terms of choosing wise plea bargains, or effectively maintaining or protesting their innocence, just more broadly.
I think questions that are coming up now in the Guantanamo context is what happens if the state has caused a mental illness because of torture, because of illegal detention. What about standing trial at that point? And that's a question that is actually going to be coming up through the courts now. Is you have made my client incompetent through torture, and therefore they're not able to stand trial.
Not able to punish it either.
Okay, we can do one more question. Then I'm going to ask the panelists again to give a final message to our group here. Yeah.
Hi, I'm Mary Ellen Keogh. I'm a graduate of the School of Public Health. And I wanted to just talk in reference to Guantanamo, specifically maybe Abu Ghraib, excuse me, this whole question of dual loyalty and what happens to health professionals when they get into a situation where they're working with the military and may be forced to work with the military. What happens to them that they lose, their health profession's mission, if you will, and what kind of accountability should there be for those who participated in these kinds of...
That is a totally loaded question.
And just one more piece to this. Dr. Annis, you referenced an ethics committee at Guantanamo, and I wondered if that committee, too, was totally military, or are there civilian health professionals and other ethicists on there? So it's a two-part question.
Dr. Crosby will be able to tell you that. I just remember reading that in the report, and I don't have the details in front of me exactly, but there was some ethics committee. I don't know if it was literally in Guantanamo or if it was a part of Central Command or something.
It's separate stateside.
Yeah, that's what I thought. Yeah.
So this whole issue of, I don't really like the term dual loyalty, but clinicians are put into a position where their commanders, their supervisors are non-medical people. So you have base commanders directing doctors on how to practice medicine. And that's how the military chain of command runs. And this has been a huge issue of debate ever since the War on Terror and ever since we've been detaining prisoners without cause. And doctors, as I described, have been caught up in all kinds of practices that normally would never happen. So we do know that over the last couple of years, the Defense Health Board, which works for the Department of Defense, has crafted a new ethics statement for military medical professionals. And it's in the final stages of being finalized and sent out. But, and Professor Annis and I have been involved in this report. And essentially, the bottom line is a physician's responsibility is to their patient. And
This would be revolutionary if it's adopted.
well, you would think it would not be revolutionary, but everything else needs to flow from that premise. The physician's primary responsibility is to the patient. And I think examining the systems that are in existence right now that actually lead to physicians and nurses being involved in force feeding, being involved in other practices that would otherwise be considered completely unethical, even illegal, are being examined, and it's not an easy solution. The military, has a structure that's hundreds of years old that it's hard to change. Change of culture is difficult. The ethics committee for the Latif case, these things in practicality don't work all that well. They do have a committee that's, I believe, in USIS, or anyway, it's not at Guantanamo. It's in Virginia or DC, where a group of military and I believe civilian consultants will meet and talk about cases. But in reality, it doesn't work all that well. And that's one of the tenets of the report, is to really support outside ethics consultants for all of these difficult cases and making them available on site so a doctor can say, I have this case, we need to talk about it, what should we do? But it's a very good question.
I think we also all agree, at a minimum, there has to be a military medical chain of command that's real.
So I was wondering about, so are you referring to the Uniformed Health Services University, the military?
Yeah, the
medical,
military
yeah,
medical
that's in Bethesda,
Right.
I want to say,
okay.
right around
That's
the
right.
Naval Hospital and NIH.
Yeah, and that's, again, as I said, when you have a chain of command where your commander is not a doctor telling the doctor to do something, it's a problem, and it results in all kinds of conflicts.
It's sort of parallel, I mean, not directly, but there dual roles come up, obviously, for people that work in prisons as well. So you have, you have a population where you're treating somebody and you're there, but things are a little bit different. So you have, you're on the street and you see somebody in the community and they say, I'm going to go out and start a riot. Don't really care. Let them do it if they want. But you're in a prison.
You
Someone
might
says
care.
that. A little bit, yeah. But you're not like under this obligation to say, oh no, this guy, they're
going to a Trump.
let's just restrain this guy and throw him in a hole or something. But so it's not going to be like that. But like in a prison, if someone says that to you, and you actually are obligated, because you're going to be putting a lot of other people at risk. And so there are things like that that are different. And you might have a warden who wants something done, and obviously wardens. I don't know if there's ever been a warden who's also been a doctor, but let's just say, so usually a non-medical person. Now you don't have anything, I think, as blatant as make a commander making medical decisions, which you might have in that case who's not a doctor, but you do have this. You have to be as aware as possible of how much you are objectively. How much you're actually putting the patient, the person you're seeing, at the forefront, working in that person's best interests, versus pressures that are that can be there and consciously or unconsciously could affect your medical decision making.
I think one of the good things quickly about the New York State system, at least when it comes to mental versus medical health, is that we were with the New York State Office of Mental Health, which has its own parallel hierarchy and structure, and people have their own bosses outside of the Department of Corrections. But even for the vast majority of other medical services, those are administered within the Department of Corrections. So the general medical doctors are employed through docs. But even there, they have kind of a parallel supervisory hierarchy and chain of command, where they have a regional medical director, and then that person has a boss in Albany who's separate from the day-to-day warden and security structure within the prison, the prison system. I think that tends to work well in terms of oversight and lack of conflict of interest.
Thank you.
Yeah, reasonably well.
Yeah. Final words. Let's start with Dr. Crosby. We'll end with Juan. We'll go down here. And we're going to end with him.
Yeah.
He gets the last word. You go ahead.
All right. I mean, this has been an incredible conference, and I just want to thank the two rapporteurs for being here today. And I guess I just only want to end with really a question: is where do we go from here? I think
we've certainly felt lack of support from our professional medical organizations and licensing boards in terms of supporting ethical behavior at Guantanamo and in prisons. And, can that be changed? I don't know. But just, think about that as students and young professionals coming forward. How can we change the culture and not only end torture and solitary confinement, but I think it's all tied also to the right to health and social determinants of health. It's all related.
I would want to second thanking the rapporteurs. It's been an honor to be part of this in any way, and it's been very, very interesting discussions that are being brought up. I do want to sort of take my time to ask a specific question that I didn't get to ask earlier, if that's okay. We didn't get to talk a lot about...
It's your time.
We didn't get to talk a lot about force feeding, and it's a particular interest of mine. And a lot of folks... I remember, Professor Mendez, when you talked about the people that have the reaction that say, "Oh, we're going to let these people die," when they go on hunger strikes, and it made me think a little bit of Hernan Reyes and the the Committee of the Red Cross, and how he laid out sort of a lot of the very basics of what people don't understand about hunger strikes, and that someone on a hunger strike isn't trying to die. They're trying to live as long as they can, specifically so they can get their demands met, and how, by definition, someone on a hunger strike has to be competent, or else it's some other process, some other situation, and how it's very rare for someone to actually go the distance and actually die. And then you had brought up the state, and there's the idea of the state having the responsibility for preserving life within someone within a situation like that. I guess my question is, if we take a pure hunger striker, let's just say specifically somebody that really is competent, has a stated reason, no question of mental illness, has advanced directives, and goes the distance. Should the state necessarily have to intervene or let them go the distance? My thought is that that's the only sort of chip that they have to play to some extent, is to ultimately say, I'm actually putting myself at risk to die, and that's what I'm going to allow myself, that amount of risk, in order for you to have my demands met. And so if people always intervene when they get to the point where there's a medical necessity, is that somehow taking away the power, even though you don't obviously don't want to watch somebody die? But in a very rare case where that happens, would it be right to let someone perish? I suppose
That is the question.
Yeah.
Brandon? No,
Well
put.
Thank you. I first just want to extend my gratitude to everyone in attendance, and to both Annises for allowing me to be a part of this today. I'll wrap up just kind of by reiterating a couple of my main earlier points. One, just that at least when you're talking about America, anytime you're talking about prison reform, prison rights, you've got to take into account that you're dealing with 51 different systems. There is some oversight at the federal level, so PREA, as I mentioned earlier, and a few other laws and Supreme Court decisions as well that do affect all the states. But for the most part, you're dealing with over 4 dozen different variations on a similar theme, whether it's general incarceration or solitary confinement, protective custody, and things along those lines. And I just, again, want to emphasize, can't emphasize enough, that there's enough variation within the state prison systems, prison to prison, even solitary to solitary, or protective custody to protective custody, that you really have to keep that in mind whenever you're thinking about studies, or whenever you're trying to advocate or advance the knowledge about the effects of the different levels of incarceration on an individual person, that you have to take into account. Some systems give people music and headphones within a few weeks of being in solitary. Others have televisions. Others, may have less stuff but there's variation, and you just have to keep that in mind when you're thinking about the different systems in America.
Thanks. Point well made. Professor Mendez.
Thank you. I agree that the 15-day maximum that the Nelson Mandela rules impose could be tempered if, depending on the conditions. I am very well aware that some people are spending solitary confinement with television, books, radio, ability to read and write and write home, etc., and visits once a week from family. But in those cases, at least they shouldn't be there for 30 years. That's the kind of cases that I have seen myself in Pennsylvania and in California. So maybe 15 days is kind of like the absolute maximum for the conditions in which there's no stimulus at all. And maybe 30 days. But whatever we extend, we should count in days, not even in weeks or in months or in years. With respect to force feeding, I very carefully followed the literature that the International Committee of the Red Cross has on this. And you're right that they have done the most on it because they have faced hunger strikes everywhere. And I realize that it's a very difficult moral dilemma. I don't want to minimize it by just saying, no, there can't be any force feeding, period. But I think on force feeding and on the question of non-consensual treatment of mental health patients, for example, outside of the custodial situation, what the international law is moving towards is towards respecting more and more the autonomy of the individual, even when the individual is a person with serious mental disabilities or a person who has committed very serious crimes. The whole idea of human rights is about human dignity, and we need to return to the premise that if these are still persons, and these are still persons with dignity, and part of their dignity is we should respect their wishes. Now, in the case of force feeding, my limit is when they are no longer able to express their autonomy and their will, and then they're still alive and the state cannot let them die. But I also insist that there's many steps before we get to that point, and many steps that the state is responsible for implementing before going straight to force feeding. Because in essence, force feeding, as we have seen it, certainly in Guantanamo, end up being another form of pressure on the prisoner, regardless of whether they are going to die or not. But I concede that this is not an easy discussion, and the moment in which things change is very difficult to ascertain. And so I'm very grateful for the opportunity to participate with people in the public health and in the medical fields, because I always get a lot out of these conversations. I am very pleased to have been able to participate with all of you, and thank you again very much for your invitation.
Well, and thank you. It's been great having you here. And please join me in thanking the panel. And I'm going to give my 15-minute wrap-up in about 15 seconds, which is just to say this has been an extraordinary day. Those of you who've been here all day, it was incredible having the two rapporteurs here. And for me, I learned a lot. I learned how much you guys overlap. I would never have thought there was overlap. But and also this movement toward...
We invade each other's turf.
That's great, you do. And also the movement toward re-examining non-consensual psychiatric care is really important, I think. So anyway, again, thank you guys for being here, and thank our panelists.